Ma'am, are you Miss Spears?
Yes, ma'am.
Thank you. This is Brianna Spears of docket 2016-687DS. In this matter, Ms. Spears failed to appear for a bench warrant hearing before your honor on May 17th of 2023. This is the fourth bench warrant with bond currently set at $1,171. Last payment made on this docket was April 4th of 2023. She paid that on her own. Friend of the court is requesting the next hearing be set for September 13th at 8 a.m. before your honor.
Thank you. Ms. Spears, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
Honestly, I had talked to one of your liaison officers last week because I knew I had another bond issued for me, and I had planned on actually today paying $250 towards my child support, but I ended up getting picked up on the bench warrant due to traffic stuff.
Okay. Well, you do have a sizable arrearage if obviously if you have the monies available. What the court can do is I'll reduce the bond to $250. You can pay that on the bond and you'll be able to be released, but you do have to show up on the September 13th date or call into your worker. I will tell you, if you don't, you won't get a favorable bond in the future. You understand that?
Yes, sir.
Okay. Thank you. You're free to go.
Can I have your name, sir?
Darrell Bozell.
Thank you. This is Mr. Bozell of docket 2022-153DS. In this matter, Mr. Bozell failed to appear on March 3rd of 2023 for a show cause hearing before the referee. This is the first and only bench warrant with bond currently set at $538. There have been no payments to this docket. Friend of the court requests the next hearing be set for September 13th at 8:45 before your honor.
Okay. Mr. Bozell, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I don't have any money right now.
Okay. Well, what happened, the court notes it is your first bench warrant, so I'm taking that into consideration, but also taking into consideration you haven't made any payments. So what I'm going to do is I'm going to reduce your bond in hopes that you could be released. And I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Well, I never knew that I was on child support. I never knew anybody even filed for child support. I just figured this out when the other day when I got arrested. I never received any paperwork or anything.
Well, what happens, the front of the court will only send paperwork to your last known address. So if you've changed your address, then they would have put it only to the last known address that they had. So that's something we can work out on the 13th, but yeah. If the bond's not posted, you'll have to remain there until the 13th.
Okay.
Thank you.
Yes, sir. Thank you.
You're excused. Ms. Platic, you're muted. Okay. Do you know, usually they'll state whether the people are working or something. Do you not have that information?
I don't have, I don't think anybody reported new employment out of this whole group. I did check that, and nobody reported anything for me to let you know of.
Okay, fine. Go ahead.
Can I have your name, sir?
Frederick Palmer.
Thank you. This is Mr. Palmer of docket 2005-1433-DM. In this matter, Mr. Palmer failed to appear on September 3rd of 2020 for an adjourned show cause before the referee. This is the third bench warrant with bond currently set at $1,398. The last payment made to this docket was an involuntary garnishment in April of 2022. Friend of the court is requesting the next hearing be set for September 13th at 8 a.m. before your honor.
Mr. Palmer, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I am, just not that high of an amount, sir.
Okay. Well, the court notes that the last payment was well over almost a year and a half ago, and that was involuntary. So I'm taking that into consideration. You do have 3 bench warrants previously. What I'm going to do is I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $400. If you're able to post that, you'd be able to be released. Do you have any questions?
No, Your Honor.
Okay, thank you very much. You're excused. You can have a good day, sir.
All right, thank you.
Can I have your name, sir?
Marty Gibson II.
Thank you. This is Mr. Gibson of docket 2019-1864 DP. In this matter, Mr. Gibson failed to appear on December 13th, 2019 for a show cause before referee Nets. This is the first and only bench warrant. Bond is currently set at $500. Last payment was collected on July 31st of 2023 through income withholding. It looks like that income withholding was active for about 3 months, collecting the full obligation. Friend of the court requests the next hearing be set for September 13th at 8 a.m. before this court.
Mr. Gibson, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to, again, set a bond so that assures your hearing, or basically your appearance at the hearing on September 13, 2023 at 8:00 a.m. You will get notice of that in writing. Yes, sir.
I never received notice of ever having a hearing here.
Well, probably what happens is whatever your address is, they send it to your last known address.
I just recently dealt with this in Indiana. The post office here was not forwarding my mail to Indiana, so I had no idea this existed at all. I have no intention of skipping out on court. I came back to Michigan to help take care of my daughter, whom I am supposed to be at home helping take care of now. My significant was just getting ready to start a job. I'm the only resource she has to watch our daughter. I came back up. I plan on bettering my life. The child support was over $2,000, sir. I brought it down to $600. I plan on selling my car as soon as I'm out of here to pay off the rest. I have no ill intentions towards skipping out on court. I was actually hoping for a PR bond today, and this is all new information to me. I also have certain health issues that require different attention, and my significant is also my caretaker.
Okay. Well, sir, it is your first bench warrant, so I'm considering that. I'm considering as well that you paid recently through income withholding. What I will do is, as a result of that, I will set your bond at 0 amount. That'll allow you to get released today. Okay? But if you are going to sell your vehicle and pay this off, you need to do that so that when we come back, we're not going to have any other issues. And make sure that you also notify the front of the court of your new address, because they'll keep sending everything to the old address, whatever that would have been.
Yeah, I just did that paperwork today. I was in the middle of transitioning. I came back up, put in vacation time, so that way I could come back up and help with my daughter, because the mother was stuck in a place that wasn't the best. There was
well, what happens, you're going to have to call in on that hearing, on the September 13th date. You'll have to call in and talk to your caseworker, okay?
Okay.
So what we'll do, it'll still take about an hour or so for that paperwork to catch up so you can get out, but you'll be able to get out this morning.
Sir, I really appreciate you. Thank you so much.
Have a good day, sir.
You too.
Can I have your name, sir?
Yeah, Hubbard.
Now, Now before the court is Mr. Hubbard of docket 2017-1926DS. In this matter, Mr. Hubbard failed to appear on April 25th of 2023 for a show cause hearing before the referee. This is the second bench warrant with bond currently set at $500. Last payment was September 15th of 2022 through income withholding. Friend of the court requests the next hearing be set for September 19th at 8 a.m. before this court.
September 19th, you said?
13th.
Okay.
Excuse me.
Yes, sir.
It should be another warrant. I know I got FOC warrant, but I got another warrant.
Okay, well, we're only dealing with the FOC.
Oh, FOC, okay.
Mr. Hubbard, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I can't even walk. I got a broken leg. I got hit by a drunk driver. That's why I haven't paid.
Okay, well, I do note that you haven't paid in almost a year, so presumably you didn't get hit by a drunk driver, a year ago.
No, not a year ago. It was. I couldn't go to court because that's what I'm saying. I couldn't go to court because of my leg. I just got dragged out the house. I'm still not here. I got hit on May 22nd. I would have paid. I do pay my child support.
Okay, sir, you were hit on, you said May 22nd. The hearing was in April, so it was about a month before you were.
I know in April my mom died and I was up there. I found my mom dead in her room. I know about court because I was coming back down here to turn myself in.
Okay.
Yeah,
well, what I'm going to do is, it is your second bench warrant, so I'm taking that into consideration, but I'm also considering the fact that it's been almost a year since you've made any payments in this matter. What I'm going to do is I'm going to reduce your bond to the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
No.
Okay, thank you. You're excused. Have a good day.
Thank you.
Are you Mr. Moore?
Hello, how you doing?
Are you Mr. Moore?
Yes, sir. Yes, ma'am.
Thank you. Now this is Daquan Moore of docket 2013-3269 DP. In this matter, Mr. Moore failed to appear on October 31st, 2018 for an adjourned show cause before your honor. This is the fifth bench warrant with bond currently set at $500. In this matter, last payment was made on September 26th of 2022 through income withholding. In this matter, the case is arrears only as the other party is deceased and Mr. Moore has custody of this child. Friend of the court is requesting that the next hearing be set for September 13th at 8 a.m. before your honor.
Mr. Moore, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I have to make a phone call if I could make a post bond.
Okay. Well, what I'm going to do is, it is your fifth bench warrant, so the court's considering that. The court is
I
considering.
got 5 warrants, bro.
Excuse me?
I have 5 warrants. I'm sorry about that.
Okay. No, you had 5 prior bench warrants.
Gotcha.
You don't have 5 warrants now. The court is taking into consideration it is only an arrears only case, but you haven't paid in a year. So what I'm going to do is I'm going to reduce your bond so that you can be released. I'm going to set your bond in the amount of $100. If you're able to post that, then you'd be able to be released. Do you have any questions?
Nope.
Okay, thank you, sir. You're excused. Have a good day.
Are you Nathan Smith?
Yes, ma'am.
Thank you. This is Mr.
Hello.
Smith of 3 Matters, docket 2009-2487 DS, 2020-2310 DP, and 2022-2456 DS. In all 3 of these matters, Mr. Smith failed to appear on August 4th of 2023 for an adjourned show cause before the referee. In the 2009 matter, this is the second bench warrant with bond currently set at $689. In the 2020 matter, this is the second bench warrant with bond currently set at $2,748. And in the 2022 matter, this is the first and only bench warrant with bond currently set at $500. In all 3 of these matters, the last payments made were on May 4th, 2023 through an involuntary garnishment. In front of the court requests all 3 matters be set for September 13th at 8 a.m. before your honor.
Thank you. Mr. Smith, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8 o'clock a.m. Are you able to post a bond, sir?
Not with it being so high at this time, no.
Okay. Well, what I'm going to do in your 2020 case, because that's the one that's most, you have 2 prior bench warrants, but you have a substantial arrearage in that case. What I'm going to do is I'm going to set your bond in that case in the amount of $300. And in each of the other 2 cases, I'll set your bond in the amount of $100. So it'd be a total of $500. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Not at this time.
Okay, thank you. You're excused then, and have a good day, sir.
Okay, thank you, sir.
Court will note the appearance of Mr. Seisel on behalf of the defendant. This matter is before the court on the defendant's motion to set aside referee recommendation and order. I do note, Mr. Seisel, and a number of the allegations in your objection go to the issue of parenting time. The court would note that a court did enter an order on August 7, 2023, referring the matter of parenting time to the referee. So I guess what I'm saying, I'm not going to address the parenting time issue today because that's going to be the forum for doing that.
Yeah, understood, Your Honor.
Okay, go ahead if anything else you have in your motion.
Yes, thank you, Your Honor. Again, Brad Seisel appearing on behalf of defendant Steve Laria. And I just want to note at the outset, just because it's important to me. So we're looking at the referee's order to dismiss objections to child support review dated June 2023. And there's a line in there that says counsel for defendant failed to appear. Again, it's important to me just to note I did not fail to appear. I was not retained to represent Mr. Laria at that proceeding. And in fact, I had already filed a notice of withdrawal of my limited appearance prior to that hearing. So I just wanted to state that for the record, Your Honor. With respect to the current objection to the proposed child support order, Your Honor, it would just take me about 2 to maybe 3 minutes just to kind of go through the procedural history that's relevant to that. But I think it helps put Mr. Laria's position into a proper and full perspective. And as Your Honor noted, it does relate to the number of overnights that are being credited to Mr. Laria with respect to parenting time, but as it relates specifically to the child support amount. And it's Mr. Laria's position that the overnights in the proposed child support order are based on an unresolved parenting time schedule for the 2 younger children. And so it's premature to have a support award at this time. So basically just, Your Honor, just very briefly with the procedure, how we got here. So August of 2022, the parties entered a consent judgment of divorce, which was entered by this court. Under that judgment, the parties were awarded joint legal and physical custody of the parties' 3 children. There was a very specific parenting time schedule prepared for all 3 children. And in the support order from that judgment, Mr. Laria was awarded 208 overnights, and Mrs. Laria, now Ms. Rabowski, I think I'm pronouncing that incorrectly, but anyway, plaintiff was credited with 157 overnights. So the amount of child support under that order was $609 per month. In late 2022, there was a request to modify custody, parenting time, and support. And by January 23 of 2023, we have a recommended order by the referee to modify parenting time and child support. And so in that recommended order, the oldest daughter continued to have a specific parenting time schedule, 156 overnights with dad, 209 with mom. But with respect to the 2 younger kids, and this is where it kind of becomes, where all this kind of comes together, Your Honor. With the 2 younger kids, the recommended order just said, as agreed by the parties, and there was no fallback parenting time schedule. And the referee recognized and stated in that order, because the overnights were to be determined for the 2 younger kids, the referee referred the child support to the friend of the court for investigation. So now we jump forward to March 2nd of 2023. Friend of the court completes its review, and the referee enters a recommended child support order. But the problem with it, it was based on a number of overnights for the 2 younger kids that the parties didn't agree on. So quite frankly, simply the parties had failed to agree on a parenting time schedule for the 2 younger kids by that date. So Mr. Laria was given 0 overnights for the 2 younger kids, and the amount of the child support jumped from $609 per month to $2,997 per month. And again, based on the parties not being able to agree on a parenting time schedule for the 2 younger kids. So Mr. Laria objected to that recommended order. In May, he filed a motion for specific parenting time. And as the court noted, at a hearing on May 30th, the court awarded Mr. Laria an interim order providing for specific parenting time every other weekend and every Wednesday. And now we jump forward to the June 20 order that dismisses Mr. Laria's objections to the support. Again, that order ties back to the back to the January 23rd, 2023 order where the parenting time for the 2 younger kids was as agreed by the parties. They were never able to agree. That's why we had to come to the court to request a specific parenting time order. So it kind of goes full circle. And so from Mr. Laria's perspective, the child support should remain at the original level until they're able to either agree on parenting time or this court gets it resolved and final. And so at the very moment, the parenting time question was referred by you, Your Honor, to the referee. The parties had a hearing on that. The referee referred the parenting time schedule for the 2 younger kids to the friend of the court. And so I think they're scheduled to maybe go back before the referee sometime in September. The parties might be able to speak to that. But so the friend of the court is currently doing an investigation. So, Your Honor, again, Mr. Laria's position is that because the parties could never agree on a parenting time schedule for the 2 younger kids, the original amount should remain in effect until they either come to an agreement or this court resolves that issue. At the very least, Your Honor, in the referee's child support order, he made it retroactive to January 23rd of 2023, which is the order that said parenting time for the 2 younger kids would be as agreed to by the parties. They couldn't agree. this court in May, again, issued a very specific parenting time schedule on an interim basis. So I think at the very least, the higher amount should cease to continue from the date of this court's order entering the interim parenting time schedule, with the final to be determined by the referee upon the front of the court's review.
Okay.
So I guess unless the court has any questions specific for
No.
me.
I'm going to turn to the plaintiff. What is your response? You're muted, ma'am.
In January, when we went to the hearing, which was due to Steve's motion to change custody, he told the referee he did not want any overnights at all, and I begged the referee to give him the ability to be able to take them as they wanted, which is why it was written the way it was. In May, the original order for proposed parenting time was not put into motion, which is why in June, the order was written the way it was for child support. You just put the motion for parenting time in order in 2 weeks ago, and he will not follow it. We're in the same boat we were already in. You wrote the order, you gave him on the order that he wrote that you agreed to. It said it started the first Friday after the order was made. He would not come and get him. He argued for 8 hours about how he was not going to follow it. He is currently, right now as we speak, he has Jacqueline for the last 2 days. He has made no attempt to see Mitchell nor communicate with Mitchell in any way other than one Wednesday night visit. He took him to dinner, and apparently it didn't go well. From my understanding, his dad took him into the gas station, and his stepmom accused him of stealing again. The same thing, which is why she threw him out of the house in November. We're right back in the same boat.
Well, we're getting into a lot of other issues. What the court is going to do as it relates to, again, the pending motion is simply when the referee does address the issue of parenting time, the referee can modify support consistent with whatever the parenting time order would be. And then we can resolve that issue at that time as well. So, Mr. Seisel, if you'd submit an order under 7 days, just stating that the referee will address the issue of support consistent with whatever the eventual parenting time order is.
Yes, Your Honor.
Okay, thank you.
Thank you.
Court will end this matter at 10:37 a.m. You're free to go. Have a good day.
Thank you. You too, Your Honor.
Anika Rodriguez and Francisco Rodriguez.
Okay.
Okay, so we have Shanika and Francisco, correct?
Yes.
Correct.
All right, calling case 2023-1520 DM, Shanika Rodriguez versus Francisco Rodriguez. Today is Monday, August 21st, 2023 at 10:39 a.m.
Good morning to both of you. The court notes that this matter is before the court on the plaintiff's motion to determine child born out of wedlock. Ms. Rodriguez, what we do is we don't do those. I mean, you filed the motion correctly, and there's sufficient basis under the motion for a hearing to take some testimony, but we don't take testimony on Mondays. That would be a Wednesday afternoon hearing at 1:30, in which the parties would be sworn in and testify. You stated that in your motion that you've lived separate and apart, et cetera, but you never give a date. So I don't know what date you're talking about from when you separated, et cetera. So I'm not able to determine some things as a result of that. But what happens, the court will give you the hearing on a Wednesday. And what happens, my office will be in contact with both of you to see when you're both available for a Wednesday afternoon hearing. I don't know, is Mr. Miller, is he disputing or contesting paternity? Ms. Rodriguez?
Yeah.
Yes, what?
He's not disputing. He wants
Okay. Well, if you could have Mr. Miller present as well, then I could take some testimony from him to establish paternity.
Okay.
Have you done any DNA test or anything?
No.
Okay. Just for purposes of clarification, you had said that you had lived separate and apart, had no intimate relations. What period of time are you talking prior to the time the child was born?
We've lived separately since February of 2021.
Okay, well, if that's the case, when was the child born?
He was born May 17th
Okay, so
of this year, 2023.
this year?
Yeah.
Oh, clear. So clearly, well, I'm just trying to determine whether we needed a DNA test, but based upon you giving those dates, clearly we won't need a DNA test. Because obviously we were able to exclude the defendant. So what we'll do is we'll be in touch with you and we'll set it up for a Wednesday hearing, take testimony, and we'll be able to conclude it then. Okay?
Okay.
Okay. Thank you both. And we'll end this hearing at 10:42 a.m. You're free to go.